Okay, let's go ahead and get started. Thanks everybody for your patience. I know that it's been a very busy couple of days and things have been going over, and I think it's because we've been having a lot of robust discussions, but welcome to everybody. My name is Young Lee, and I am the Director for Financial Transparency and Regulatory Policy in the Office of Terrorist Financing and Financial Crimes at the U.S. Department of the Treasury. And I'm very fortunate to be here surrounded by an illustrious group of panelists, and including, hopefully on the screen momentarily. Okay. I'd like to just thank the IACC organizers and my fellow panelists and everybody who's here today for this discussion. You are here for the panel on anti-corruption through financial transparency, the societal benefit of collecting beneficial ownership information. If this is not the panel that you have a ticket for, please exit the jet bridge and find your appropriate flight. I think we want to make sure that we leave enough time for you all to participate. I think we all understand that you all bring a lot to the table, so I want to make sure that we just dive into the meat as quickly as possible and give you all a chance to engage with us in the question and answer session. So, you know, the panel, we've convened it today to underscore the importance of strengthening beneficial ownership transparency. I think that's something that a lot of you are aware of. It is something that has been a consistent theme and thread throughout a lot of the proceedings, from the National Security Advisor's speech that kicked this off to a number of the panels, including this one here today. I think during the course of this, I hope that we will highlight the extent to which the misuse of legal persons remains a significant money laundering vulnerability, not just in the United States, but around the world, because of the interconnectedness of the global financial system. And this is something that I think a lot of countries in the world have a lot of improvement, including the United States. I think we are very well aware of the significant gaps in our regime until very recently. I think we're the first to recognize that the low that we received for immediate outcome 5 in our 2016 mutual evaluation was not a good look, and we have been striving to remedy that gap ever since, and we'll talk about that briefly today. I think one of the things that we hope you'll get out of this is that a lot of the regulatory and legislative efforts to improve beneficial ownership transparency are really key foundational elements to the fight against illicit finance and corruption. So, we'll highlight that in the course of, I think, the remarks today. Before we get started, I want to reiterate, at least from the U.S. perspective, our implementation of the Corporate Transparency Act is an ongoing regulatory process. So there are going to be limits on what the U.S. government participants here are able to say. And as most of us here are representing governments, there are going to be limits on what a lot of us say, so I hope you will not take offense. I think we are interested in having as robust a discussion as possible, but please do not take offense at me subtly or not so subtly deflecting questions that we cannot answer. So let's dig in. Our hopes, our goals today are to translate and demystify the issue of beneficial ownership transparency, though I suspect that many of you do not need that, to underscore its relevance to anti-corruption efforts, and to reiterate the broad benefits that beneficial ownership transparency can bring to our respective countries. So I have the great pleasure of being surrounded by experts, both here and on the screen. To my direct left, I have Susan Schneider, who is an attorney advisor at the U.S. Department of Justice Money Laundering and Asset Recovery Section. To her left is Mike Dobson, senior advisor for the Financial Crimes Enforcement Network, the U.S. Financial Intelligence Unit. To my right, I have Andrew Preston, head of the Joint Anti-Corruption Unit of the UK government. And on the screen, I have Ashish Kumar, team lead in the Financial Action Task Force Secretariat, based in Paris, somewhere where I suspect many of us would like to be in person, if not virtually. So let's turn it over to my fellow panelists to give some brief introductory remarks, and then I'll dig into some questions, and then open it up to Q&A from all of you. So Susan, why don't we start with you?
Thanks, Young, and can everyone hear me? Yes. Thanks so much for inviting us to join the panel today. Thank you all for attending. It's great to see everyone. So as Young said, I'm an attorney at the DOJ, so of course let me start with the standard disclaimer that the comments today are my own. They are not the Department of Justice views, and I'll be talking about my experiences. I work on policy issues on both on the money laundering side and illicit finance more broadly. So just to start out, from the law enforcement side, beneficial ownership and the information behind, getting the information on beneficial ownership is a significant issue, of course. You're probably all very familiar with both the magnitude and the gravity of illicit proceeds globally, but it may bear repeating that one estimate pegs the amount of money laundered each year at between 2 and 5% of GDP globally, which is as much as $2 trillion. And of course, this laundering of money doesn't harm just our citizens and our financial system. It also undermines the rule of law and our democracy. One of the most effective ways to tackle this and to deter criminals is to follow the money. And this helps not only with prosecutions of criminal activity, which is what the DOJ does, but it also allows law enforcement to halt and dismantle bad actors. This is where beneficial ownership information comes in and is where it's very important. So in recent years, sophisticated criminals have increasingly sought access to the U.S. financial system through the misuse of corporate structures. Because, as many of you know, our state and federal regimes don't really require information on the people who own or control these entities, the process to obtain the records for investigations can take a long time. It can take anywhere from weeks to many years. And the process can be even longer when we have to get information from other countries, which happens in a lot of investigations that involve many countries and the movement of money internationally. This is why the department has called for more effective legal frameworks so with the broader idea that if we can stop criminals from hiding behind these shell companies, it will help us investigate them further.
Great, thank you, Susan. Mike?
That tee-up is actually the perfect place for me to talk about what we've been doing over at FinCEN and give a brief update on what a lot of you are probably already tracking around implementation of the Corporate Transparency Act, which is the congressional response to some of the issues that Susan just touched on. The Corporate Transparency Act, or the CTA, was enacted along with the broader Anti-Money Laundering Act of 2020 as part of the National Defense Authorization Act for fiscal year 2021. The CTA added a new section to the Bank Secrecy Act, the BSA, which FinCEN administers, that requires reporting companies to report beneficial ownership information, BOI, to FinCEN. In general, and again, this is subject to 23 exemptions in the statute itself. Reporting companies are entities that are created or registered to do business in the U.S., depending on if it's a domestic or a foreign entity, by the filing of a document with a Secretary of State or similar office. Again, that is a statutory requirement. FinCEN actually issued our final rule about reporting requirements back on September the 30th of this year. So if you haven't seen that, I would encourage you to go and read it in detail. The requirement to report becomes effective on January 1st of 2024. Reporting companies formed before that date will have 1 year to report their BOI to us, so by January 1st of 2025. Reporting companies formed after that January 1st, 2024 effective date will have 30 days from the date on which they are put on notice of their creation, either directly or by public notice. In addition to the reporting requirements outlined in the rule that we published on September 30th, the CTA also authorizes FinCEN to disclose BOI we receive from reporting companies to specified recipients, all subject to very robust security and confidentiality protocols. We are working right now to issue proposed regulations to implement those access provisions. We've already committed publicly to getting that done by the end of the year. We are now into December, so keep your eyes peeled for those proposed rules. Finally, the CTA also requires us at FinCEN to revise our 2016 CDD rule, Customer Due Diligence Rule. to conform to the CTA itself, and then to account for financial institutions having access to beneficial ownership information. That revision process is due to be complete by January 1st of 2025, so stay tuned for a rulemaking on that as well. We are also currently working on developing the IT system into which we will gather and store and manage all of the beneficial ownership information, and all of that is supposed to be operational by January 1st, 2024, of course, when the reporting rule becomes effective. So all to say, a lot going on in the beneficial ownership space. We take this extremely seriously, and I would encourage you all to not only read the rule that we just issued, but also to stay tuned for these upcoming rulemakings as well.
I'll turn it over to Andrew now.
Great. Thank you, Young, and thanks for the opportunity to be here to talk about this important topic. I'm going to give you, hopefully, an international perspective and also the perspective of an anti-corruption expert rather than a beneficial ownership expert. I think Susan's already really made a good case around the importance of this agenda and why beneficial ownership information matters. And actually, I should say, from a personal reflection, I think this week has been really encouraging to see the level of debate and to see the level of political commitment to action on beneficial ownership and access to information. I think that's really, really important. I'm going to just make three really quick points. Firstly, just to talk about how we in the UK think about beneficial ownership information, talk a little bit about what we're doing, and then a final message around complacency. I think the key thing for the UK is that public registers of company beneficial ownership information for us serve a multiple range of purposes. So addressing anti-corruption and dealing with criminality, I think, is very important within that. But also actually a fair and transparent trading environment for businesses. Many of our businesses tell us that they want good quality beneficial ownership information because it helps them do business with confidence. And finally, there was an element about increasing trust in our government, which I think is an element that people don't think about in relation to this. But in the context of the Russian invasion of the UK and Russian money in London, I think that element of trust in government has come out really clearly. So we see public registers as serving those purposes best because they allow access for investigative journalists, for civil society, for businesses, and for law enforcement. And we recognise those elements. So I would say a couple of key arguments there. So national security, prosperity, and trust in our institutions are how we think about it, and you need to act domestically and internationally. So a couple of words about what we're doing. I would say, firstly, there's a set of work around sort of acting at home. We passed some legislation in the spring, which was around introducing a new company register for foreign companies owning property in the UK, and that is now being populated and will go live from the end of January. We currently have legislation in Parliament called the Economic Crime and Corporate Transparency Bill, which will strengthen our Companies House, and I'll probably say more about that later, but that's a really important set of legislation, and ongoing work to strengthen capacity. Second element I would mention is active engagement with our overseas territories and our crown dependencies. So these are self-governing, largely islands, which are part of the United Kingdom, and we are supporting them and working with them to improve their beneficial ownership information and support the development of public company beneficial ownership registers. And the third element I would say about the UK is that we're acting internationally. A lot of that is about engaging with international partners to build recognition of the importance of this agenda, to help raise standards. A number of different channels for that. I think the FATF, and Ashish will probably say more about the review of Recommendation 24 in a few minutes. That is key. There has been progress through the German G7 finance track over the last year, and we also, the UK, are working with 7 other countries through something called the Beneficial Ownership Leadership Group to promote a global norm of beneficial ownership transparency. So a lot of activity happening. My third message really was that there's no room for complacency on this agenda. I think both. I think Young had a tone of humbleness. I think the UK, we have a tone of humbleness. We know that not everything we've done on our domestic side is brilliant. We know we have more to do. We're working on that. And we also know that the criminals are constantly evolving and changing. And so we need to be agile, and we need to really drive forward progress so that we can keep up with them. Thanks, Young.
Thank you, Andrew. And then last but not least, Ashish, and I think it is quite late in Paris, so thank you. I forgot to acknowledge, we appreciate you staying up to participate here.
Thank you, Young. Just a mic check. Can you hear me?
Just a second, we can't hear you.
I have unmuted myself, so probably you
great.
should get. Oh, you can hear. Okay, perfect. Thank you, Young, and good afternoon, everyone. A huge thank you to organizers for putting together this important panel. And my apologies for not being there in person. Paris is pretty damp, and gray and gloomy right at the moment. So I don't think you are missing any action by not being here. Just to give you a brief landscape of where we are on beneficial ownership work. In fact, FATF has been working on beneficial ownership transparency issues since 2003, I think, when we first issued the standards. And we have long recognized that transparency about ownership and control is a key tool to prevent the misuse of legal persons in laundering the proceeds of corruption and other serious crimes, and also to prevent financing of terrorism. And these are some of the cases which we have found in our studies over the last few years, which have been proving over and over again that this is an area where absolutely there cannot be any complacency. Our mutual evaluation reports, unfortunately, haven't given us a very good picture. In fact, if you look at the results which we published earlier this year in terms of a stock take of around 120 evaluations across the global network, we have observed that only 9% of the countries, that's right, only 9% of the countries have effectively implemented laws in this area. And just about half, or around 52% of the countries have necessary even laws or regulations in place. And that gives a very gloomy picture about how things are working in practice. And these loopholes allow corrupt actors and other criminals to hide their involvement and get away with their ill-gotten gains. In fact, 4 years ago, we, working together with the Egmont Group, published a report on concealment of beneficial ownership. And the report identifies around 100 case studies provided by 34 countries, which identify the methods, the techniques, the tools criminals use to hide beneficial ownership. And the ease with which these complex legal ownership structures can be formed, the role of company service providers in their formation, the use of nominee directors and shareholders, all increase the risk of their misuse by shielding the real people behind those structures. And that is why the FATF recognize the need for updating our standards, as well as to reinforce the implementation of the existing standards across the global network. And after undertaking a review of, for more than 2 years, and in fact, multiple public consultation as well with the private sector, we adopted revision to our standards in March this year. I will give you a very brief flavor of what these revisions talk about and their implications for all of us. And I think the first key element of this change to Recommendation 24 is to explicitly require a multi-pronged approach. I think this means that countries will now be required to ensure that beneficial ownership information is held by a beneficial ownership registry or an alternative mechanism. And countries should ensure rapid and efficient access to beneficial ownership information to competent authorities. The information has to be adequate, accurate, and up to date. And I think this is the key element of the effectiveness of the system. To what extent the information is, verified, to what extent this is up to date, and to what extent it is adequate in terms of revealing the true picture about who the real owners or real controllers of a corporate structures are. In terms of risk assessment, now there's an additional requirement for countries to not only assess and mitigate the risk of locally created companies, but also to go beyond that and look at the foreign created companies, the risks to which they are exposed to. And this is something which is a key element of the revisions, that countries need to identify, those foreign legal persons which are having sufficient link with their country, and then identify, understand, assess, and mitigate the risk, arising out of those structures. The FATF also agreed to ban creation of new bearer shares and to strengthen disclosure requirements for nominee arrangements. That is, when a person acts as a director or as a shareholder for someone else. The revised standards also require greater access to beneficial ownership information in the course of public procurement, and that is something which is extremely crucial in order to prevent and combat corruption in this space. And last but not the least, I think the revisions also aim to sort of provide quicker and more effective international cooperation in sharing of beneficial ownership information. And in fact, our studies and our experience has shown that many of these structures are, in most cases, multi-jurisdictional in nature. Companies are formed in one country, assets are held in another. Sometimes, bank accounts are also held in a third country. The company formation agents and nominees might be residing in another. And these kind of complexities in the structures sometimes frustrate investigators and law enforcement agencies in their efforts, and that's why greater focus on international cooperation in this area is extremely vital to ensure the countries are able to share that information, and that is something which is mutually beneficial for all countries. So we have worked on that area as well. In terms of where we are in terms of implementation, we are currently finalizing a guidance to help countries in the private sector implement the new requirements. And the aim is that we should be publishing that guidance in February next year, so that we can provide more clarity and more guidance to countries as to how to go about the implementation efforts. And my last point is about the legal arrangements. We have worked extensively on legal persons, but we haven't forgotten about some of the legal arrangements like trusts, which exist in many countries. So we are also aiming to strengthen our requirements, which are applicable to these structures, and we are also aiming to publish the revised standards for those structures in February. So this is a very brief snapshot of where we are on transparency of beneficial ownership. Happy to answer any questions later in the discussion. Over to you, Young. Thank you.
Thanks, Ashish, and thanks everybody for providing us a good overview of the landscape. Now that we have that foundation, I'd like to dig a little bit into some of the themes that we explored during opening remarks. So let's start with Mike. I know that some states here in the U.S. have been flagged as major destinations for foreign assets, and that attraction is due in part because of the ways that these states allow true beneficial owners to obscure their identities through shell companies and other ways of obscuring who owns and controls. What does the beneficial ownership reporting rule under the CTA mean for these states?
Sure. Young, I obviously don't have to tell you that this is something the Treasury has been concerned about for quite a while now. So we were excited to see the CTA come and what it means for us. Obviously, this will set a national standard for what is required in terms of what has to be reported to the federal government. Obviously, the states, of course, are still free to do as they please and require whatever BOI they think is appropriate, but this will at least set a floor on what law enforcement agencies, financial institutions, and others will have access to for purposes of protecting national security, the U.S. financial system, and generally adding to all of the transparency efforts that we've talked about here today so far.
Great. Thank you, Mike. And so, Susan, I want to turn to you really quickly. A lot about what we are doing when we're trying to collect BO information, and at least a lot of the focus for our framework has been about equipping law enforcement and prosecutors with the information that they need to hold criminals and corrupt officials to account. What challenges does law enforcement face with the result of the lack of beneficial ownership information? I know you touched upon this briefly, but I'm wondering if you could touch upon a little bit more detail, some cases or specific anecdotes about some of the impediments and some of the value of beneficial ownership information.
Thanks, Young. Sure. So as I mentioned, obviously beneficial ownership information is critical in law enforcement investigations, to peel back, figure out who's behind who's actually acting through these entities. But the process takes time, and that time, the longer it takes, the longer it gives criminals to move their funds or layer them to further conceal their ownership or their location. So currently, to unveil the true ownership, we're talking about obviously the CTA is not yet implemented, but currently to unveil the true ownership of a structure associated with criminal conduct, investigators might need grand jury subpoenas, they might need witness interviews, they might need foreign legal assistance. They may have to obtain information formally through mutual legal assistance treaties, which takes time, of course. And then if the beneficial ownership information belongs to an entity that is registered in a jurisdiction where there is no bilateral mutual legal assistance treaty, that can make it even more difficult. In addition, and I think it's important to mention this, once an investigator gets the actual ownership records, they may just discover that the entity that they were looking for is owned by another entity, which means that the process starts over again. So all of this, again, takes time, and as that time elapses, the money can move to other locations, or the assets, or whatever the form of the proceeds. So, I mean, one example is the 1MDB matter, or One Malaysia Development Berhad investigation, which is a DOJ investigation going back a number of years. Just as background, there were many billions of dollars in funds belonging to 1MDB that were allegedly misappropriated by high-level officials and their associates. So 1MDB was created by the government of Malaysia to promote economic development. And the associated funds were meant to be used for improving the well-being of the people. The co-conspirators in the case allegedly laundered the funds through a series of complex transactions and shell companies with bank accounts in the United States and abroad. And included in the DOJ forfeiture complaints, or the forfeiture efforts, were a number of luxury properties in New York, LA, Beverly Hills, and London, mostly in the name of shell companies. I think there are obviously other examples. I think if you do a quick look through DOJ cases, you can see shell companies in a number of different actions. And in fact, my colleague Mike pointed to the FinCEN rulemaking. One of them talks about the use of shell companies in sanctions evasion, for example. I think you can also find cases of COVID-19 fraud. There's kind of a range of cases.
Thanks, Susan. Andrew, I'm going to turn to you really quickly about the UK experience. As Mike highlighted in his remarks, the US is in the process of developing a non-public central BO registry through the implementation of the CTA, consistent with the direction that we've received from Congress. The UK, on the other hand, has already had a framework for BO information collection on the books for some time that requires public disclosure. So Andrew, even for countries with existing frameworks for collecting this information like the UK, what challenges have you experienced in this domain? How is Companies House thinking about these challenges? And are you able to share any specifics on some of the reforms that Company House is considering?
Thank you, Young. Yes, I think the first thing to say is that these processes are complex and technical, and so it takes time to get them right. I think I would probably highlight two sets of challenges in relation to the UK's persons of significant control, or our company beneficial ownership register. So the first one is around the scope and coverage. So I mentioned previously that the PSC register currently covers UK companies. The legislation we introduced this year for a new register covering foreign companies owning UK property, that register was required because if you're a foreign company, you don't need to register with the UK's PSC. So we had a gap in our beneficial ownership information, a vital gap because it related to UK property, which is obviously an area where there is potential for significant money laundering. So that is one challenge around scope. We have had to deal with that through primary legislation. The other challenge that many people in this room will be very, very aware of is around the quality of data that has been held in the UK's PSC register. So the quality has not been sufficiently strong. And the legislation, the Economic Crime and Corporate Transparency Act that is going through at the current time is seeking to address that. And I'll probably just, if it's okay, Young, I'll just set out 3 or 4 different areas where we're looking to address those weaknesses. So the first of those is around introducing identity verification requirements. So this essentially covers if you're a director, you're a beneficial owner of a company, or you're somebody filing, you need to provide more verification of your identity so that we actually know the real people involved with that company. The second element essentially is broadening the powers of the registrar of Companies House so that essentially he or that entity can become a much more active gatekeeper over those company records. It's able to check, to remove, to decline information much more proactively than currently happens. The third element essentially is around improving the financial information on the register so that it's more reliable, it's more complete, and it's more accurate. So that it really is recognizing the latest advances in technology and allows better business decisions. The fourth element relates to the sort of investigation and enforcement powers, and that is really strengthening those for Companies House, so that, and including within that better cross-checking of data. And then there's a last element, which essentially is around the protection of personal information. I guess the other element that I would flag is really to return to that generic point. And the UK's PSC was first established, I think, in 2016. The pace of advancement, both technologically in terms of data, but also in terms of the activity of criminals, is very, very fast. So there is, again, we come back to that question about moving quickly and being agile, which I think is a further challenge in this type of initiative.
Thank you, Andrew. So let's turn now to the international standards, which Ashish gave a great overview of. Ashish, you highlighted these recent efforts to enhance the FATF standards on transparency and beneficial ownership of legal persons via the changes to Recommendation 24. And could you talk a little bit about what key stakeholders' reaction to these changes have been, as well as to the proposed changes to Recommendation 25, which pertain to beneficial ownership transparency of legal arrangements? And are you able to share a little bit more about what the FATF is considering in its efforts to combat corruption in line with the FATF April Ministerial Declaration and under the Singaporean presidency, which I know is being represented here at the IACC by Raja Kumar?
Thank you, Young. Yes, so as I mentioned, the R24 changes were pretty extensive in terms of our engagement with the private sector. We had, a very robust white paper consultation last year when we sort of, put out the high-level policy questions to the private sector in terms of the approach or the direction these amendments should take. And then we had a red line revisions also, which were put up for public consultation, where we not only had a sort of, a written process, but also engaged with the private sector in terms of setting out the rationale and implications of those changes and what they mean in practice. So I think overall, we have had great engagement with the private sector, with different stakeholders, with civil societies and others. And overall, there has been a very positive feedback, not only about the process, but also about the content of these changes and the sort of, impact these changes might have in terms of, implementation going forward. On R25, we just finished public consultation, finished in the sense that the deadline for written consultation was over, this week and on Tuesday, and we have had very robust responses, almost, I think, 60 to 70 responses, which came to our kitty, and we are now absorbing all of them and trying to make sense of them and seeing, what changes we need to make in terms of, those revisions which we have put out for consultation. So overall, I think it has been a great experience for FATF. It has been a great engagement process with the private sector on those revisions. Coming back to your second question on what we are doing on corruption, especially in the context of the April Ministerial Declaration and the Singaporean presidency priority, I think this is an area where we have long recognized that corruption and money laundering are intrinsically linked, and in fact, a strong anti-money laundering framework can help combat corruption and other crimes. And in that context, I think the FATF ministers this April further strengthen our focus on corruption by making better use of anti-money laundering tools and by addressing a number of issues which are sort of common across these two streams. And I think this renewed focus also sort of shows a recognition that recognition of the role that FATF standards can play and the part of work in general can play in terms of tackling corruption. And I would highlight just three work streams which have sort of come out of these initiatives. The first work stream is related to our work on further strengthening our assessment process, whereby we are working on a toolkit for our assessors in terms of how they assess countries' implementation of United Nations Convention Against Corruption. So the idea is that we'll create a handbook for our assessors, and that handbook will sort of guide them in terms of how they should look at compliance of countries' with different articles of the convention, so that they are able to focus more clearly on that aspect of the evaluation. Secondly, we also launched a new project on how citizenship and residency investment schemes can be misused by corrupt actors and criminals. And the idea of taking this project forward is to identify typologies, case studies, and in fact explore the collective experience of countries and the private sector regarding some of those risks, and also to identify some of the best practices which are out there, which can help countries address and mitigate those risks when they launch such kind of schemes. And my third and final point is about the work stream which we are recently launched on assessing compliance by the designated non-financial businesses and professions. These are like gatekeepers to the financial system, entities and professions such as accountants, lawyers, company service providers, real estate agents, and the review will sort of focus on to what extent preventive measures are being implemented by these sectors. Measures such as customer due diligence, politically exposed person requirements, internal controls and procedures, and to what extent even supervision of these sectors is being carried out by supervisors and by self-regulatory bodies. So I think these three work streams will give us a better sort of toolkit to address corruption and also the related money laundering arising out of it. I'll stop here, Young. Over to you.
Great, thanks a lot. And so I think we can't really have a panel on beneficial ownership transparency without addressing recent developments in Europe. On November 22nd, the European Court of Justice it issued a decision that invalidated public access to beneficial ownership registries under the money laundering directives on the basis of data protection and privacy. I note that subsequent to that decision, a number of EU member states have restricted general public access to their beneficial ownership registries. I know that obviously there are differing views on whether a registry should be public or private. That's not the debate that we're going to come close to concluding here today. And I would also note that I'm sure that our governments and the FATF do not really allow us room to comment on other jurisdictions' court decisions. But I am interested in views of everybody on the panel, to the extent they are willing and able, to reflect on the import of this decision on the path forward and any reflections they might like to offer. Who wants to take that hot potato first?
Thanks, Young. Can I go first as the country with a public register? So I think a couple of things to say is, I think the first thing to say is it is a very significant decision. And I think we in the UK government, and I think many of the people in this conference, are actually studying it in detail and working through the implications of it. And I think it's going to take a little bit of time for that to happen. I think our initial view, although we are actually obviously consulting with lawyers on this, is that the ruling is specific to the EU context and EU legislation. Within the UK, our justification for public access has a broader framing than the narrower money laundering specific focus that is found in the EU directive. So our initial view is that our register remains valid, but we are assessing the degree to which there is a risk and a likelihood of a successful challenge to the UK beneficial ownership registers. Having said that, the points I made at the beginning of this presentation, that public is best from our UK perspective, hold. As mentioned before, we believe there's a number of different policy objectives that these registers serve, not just criminal enforcement, but also prosperity, also trust in our institutions. And we feel that there is a broader community that would benefit from access to those. So our policy position as the UK government holds. But I would say there is going to be a tail to this, and we're going to need to work through the domestic and the international implications of it for us as a country and how we engage with this community on it. Thanks, Jan.
So I will say absolutely nothing about that court decision, but I will say that if you look at the CTA, it is very clear that that tension between the benefits of having beneficial ownership available for national security, law enforcement, and other purposes, the tension between that and issues around data security, confidentiality, these things that a lot of the folks in Congress who worked on the bill and a lot of Americans, treat very seriously, that tension is reflected throughout the CTA, and we were very mindful of that in crafting the upcoming access rule that when it comes out, I encourage everyone to take a look at and see what you think.
And I would just add, again, not commenting on the decision in Europe or on the active rulemaking, but I think to my colleague's point that the CTA, the CTA essentially, just as a factual matter, it has very specific requirements around access and access by law enforcement, access by states. It's very specific, and there are a defined set of terms around that, so it will not be public.
Ashish?
Thanks, Young. You already answered on my behalf. We don't really comment on court judgments, more so. This is a Luxembourg-referred case, and Luxembourg is under mutual evaluation right now at FATF, so it will be inappropriate for us to comment on that judgment in that context. But that's the short answer. The long answer is that, in fact, the ruling really doesn't contradict the FATF recommendations regarding beneficial ownership, because if you look at the standards, they require competent authorities to have access to adequate, accurate, and up-to-date beneficial ownership information through a beneficial ownership registry or an equally efficient alternative. And we have to also keep in mind that the FATF recommendations take into consideration that they have to apply to more than 200 jurisdictions with very different circumstances and framework, and that is why the updated recommendations sort of have a provision that countries could consider public access to information, but they don't really require that public access to information held in registries. And in fact, it is for the countries to determine what is sort of right and appropriate in their context, based on their own individual circumstances. So to that extent, the ruling really doesn't affect the standards as they are in current shape, as well as the guidance which we are working to implement those standards. Thank you.
Thank you very much. So let's open this up for questions. I would have a few requests. If you have a question, please specify which panelist or panelists you would like to direct it at. If you have an observation, that's great, but please keep it brief. And we have people going around with mics. If there are questions that we can't answer, I will politely or not so politely say as much. I think I'll just let the person who has the mic go around and...
Thanks so much. My name is Sasha Caldera. I work for Publish What You Pay Canada. And for the past 4.5 years, we've been advocating for Canada's government to create a publicly accessible beneficial ownership registry. I just want to thank all panelists for this really informative session. In Budget 2022, our country committed to a publicly accessible registry with verified data. And our approach is to align with the UK, given our foreign policy and diplomatic overlap. And I just want to congratulate the UK on holding strong on its on the benefits of a public registry, going beyond the AML focus. My question is more for the FATF and for the folks talking about the Corporate Transparency Act. In the CTA, is there an ambition to ensure that data in the registry will be verified and eventually that BO data will be centralized? And for the FATF, is there also room to recommend the utility of the registries beyond competent authorities and law enforcement? So kind of providing that utility for businesses and upholding democratic institutions, combating fraud. Thank you very much.
Thank you. Good questions. Let's turn it over to Mike first to deal with the verification question, and then Ashish to deal with the question about, I understood it as whether there's appetite in the FATF to expand access beyond AML. Is that a fair characterization?
Yeah, just the benefits beyond.
The benefits beyond AML.
Sure. So the verification issue is a tricky one in the United States because it requires you to be able to pull information from disparate resources, right? You've got state level filings. You have to figure out, okay, does this person actually live at this address? Is this business actually registered to this address? Does this person sit where they say they sit in the org chart? It's a very complicated dynamic when you're dealing with 50 states, tribal lands, territories, all of the above. And it can be an expensive proposition if there's even a solution that allows for all that to marry up. So all of that to say, it is something that we're looking at. It's very complicated, and but it is something that we're focused on.
Ashish?
Thank you for the question. So as of now, the standards require access to beneficial ownership information by competent authorities, and that's something which is a must. Every country needs to ensure that access. Also, in terms of public procurement, there's a requirement that countries should have some provisions in place whereby public procurement authorities have access to beneficial ownership information, for example, in the context of some of those contracts. So these are some of the basic minimum requirements which the standards require countries to put in place. But beyond that, I think it's for countries to have the flexibility to determine what is best for them. So in some countries, there's already an expectation that financial institutions and these businesses and professions are sort of given access to this information so that they can better comply with their customer due diligence requirement. In some other countries, there's also public access to beneficial ownership information, and these are the areas which are best left to countries to determine rather than for the standards to prescribe, because we have to accept that the standards apply to more than 200 countries, and it is very difficult for global standards to set one set of rules which applies to all the countries in every context. And that's why there's inherent flexibility which sort of provides sufficient leeway to countries to go down the road they want. Thank you.
Great, thank you. Next question.
Thank you. My name is Delmira Matekubo. I am from Uzun Investigations based in the UK at Ulster University. My question is to Susan, and it's very specific. As it touches multiple jurisdictions, so the case of Gulnara Karimova, and recently we had a decision of this Swedish prosecutor who decided that she was not a de facto government official. Therefore, she was able to return about $300 million to herself while she's in jail. So she's a kleptocrat. She's PEP. She had sovereign power in Uzbekistan, and in a kleptocracy where power operates behind the scenes. So it's not exactly the ministries or whoever have official power. It's like in a Muammar Gaddafi case, right? Men in the tent. We have women in the tent. So we have feminist kleptocracy. Anyway, the prosecutor failed to prove that she was de facto official. So what do we do? How do we prove that? And then, maybe you could help us with our network. We have an asset return network on Uzbekistan. So I really look forward to your answer. Thank you so much.
Yeah, I'm afraid I can't really comment on a fact pattern. I'm sorry. It's not, in addition, I'm a policy attorney, so I can't really comment on the facts of a matter.
I believe we have this gentleman here, and then I think in the back after. Yep.
Thank you, and a tough panel. I can appreciate it. So I'll try to avoid you putting your deflectors up. Okay?
Thank you.
My name is Mike Lockney. I'm largely right now an instructor in financial investigations, mostly to the state and local level of investigation. This database has me very interested because all the time when I'm training those guys and that group in dealing in investigations, they need access to this information. I understand that the current ruling as it's being developed will have some impediment, and I know it's been in flux, so if you could explain what the current level is on consideration, because it used to be some kind of a court order. Now I understand it might be something at a lesser level for the states to actually have access from a law enforcement perspective to see what's in there. Second question, if I might, is Currently, know your customer beneficial ownership information is in the parameter or in the range of financial institutions under the Bank Secrecy Act, under various laws, under the FATF, in compliance with those requirements. There's a whole lot of information there that with the coming of this law, how will that interact, work between what they currently gather as part of their Know Your Customer due diligence process, which is going through a verification process. My understanding of the way the database is being set up is that as it's coming in from the states, there is no verification. So what's the check on the quality of information that's coming through? They have quality information because they verify the data. What's the connection that might happen there? And the final point, again, avoid the deflectors, is at the same time that this law passed, a law passed relative to correspondent banking, which allows, if a correspondent bank with a foreign bank in the United States is allowed to have, it has access here, the U.S. can reach through that portal to that bank, no matter where they're located, to collect banking information of any kind, which would include beneficial ownership information. How is that, or will that, interact with this whole package that's being pulled together? Again, thank you for your time.
Thank you. So let me try to condense that. So for the first question, I think on the tiers of access contemplated in the CTA, I'll turn to Mike. And on the second question about the interplay between the CTA and potential revisions to the CDD rule, I'll also turn to you. And then on the third question, I think I just want to clarify, is that the expansion of the subpoena authority in the CTA? I think we can give a high-level sort of answer to that, but why don't we have Mike answer the first two questions?
Sure. So on the state and local piece, the CTA authorizes state, tribal, and local law enforcement agencies to obtain access to BOI as long as they have an authorization from a court of competent jurisdiction.
Okay, that's fine.
We will outline those parameters in the upcoming access rule that I've touched on. With respect to KYC elements, unfortunately that will be a big part of what we get into in the customer due diligence revisions that the CTA requires by January 1st, 2025. So that will be a part of that rulemaking.
And then just on the expansion of the subpoena authority under AMLA, I know that this is something that has been of great interest to a number of international partners, and I would just note that the guidance that we have received is that it is just a continuation of existing subpoena authority and will be applied in the exact same manner with the exact same checks
Yes.
in place that the Justice Department has in place. It's not a new authority; it's an expansion of an existing authority. Sorry that my deflector shields are still up to 65%.
Thank you. Thank you. I'm Duncan Hames from Transparency International in the United Kingdom. My question is essentially for our US representatives on the panel. Thank you all very much for your contributions. The British register, as we've heard, being public, is available to be interrogated by law enforcement agencies wherever they are in the world. And the registers of British Overseas Territories, whilst closed, are available for interrogation by British law enforcement agencies on a 24-hour turnaround basis and have been now for several years. So I'd be really interested to know how you envisage the information that will be on this register as a result of the Corporate Transparency Act assisting in the investigations of law enforcement agencies in partner agencies in other countries.
Sure. So that is actually explicitly contemplated in the CTA. Some of the language in that provision, I'll be candid, is a bit challenging. But the overall scheme essentially is that non-U.S. Law enforcement agencies, prosecutors, and judges can submit requests for BOI through federal agencies here in the United States. And there are a number of conditions. They can come according to the statute, they can come by way of a treaty, or they can be through a sort of trusted country determination. But that is something that we will spend quite a bit of time elaborating on in the upcoming access rule.
And I would just note as sort of a broader policy matter, I think that we, the USG writ large, I don't think this is controversial to say, are fully cognizant of the importance of really robust international cooperation in this regard. I think that we've, a lot of what we have discussed and seen throughout various panels is the important, the cross-border nature of a lot of these corruption schemes that we see that use legal entities, and the importance of being able to share that information as robustly as possible.
Hi, Charles Tavares. I'm more like a victim. I used to be an entrepreneur in Florida. And in 2011, I started being defrauded by my attorneys, which are part of criminal enterprise, using Mossack Fonseca and so forth. And my question is, the new laws and everything is great, but how are you going to address the issues? Like, you cannot even find who's the ultimate beneficiary's address or anything. And in my case, since 2011 to 3 months ago, when they transferred my last properties in Florida, they continue to use bogus people, fake people in Panama. They used, they so brazen that shameless that they used former nominees from Mossack Fonseca from 10 years ago that being used 20,000 times, and they go to a notary in Panama City, bogus document, wrong company name, wrong date, doesn't matter. They notarize, send it back to Miami. They transfer my properties, and everything's fine because the attorneys, it's a big criminal enterprise comprised of attorneys in Miami, Panama, Switzerland, Brazil, and Portugal. And they don't even have to go to anybody in Panama or Switzerland anymore. They just use, ghosts, just signatures, as long as, they just say, okay, this is a real signature, and it's been happening for 11 years with me. I've been to the FBI in Miami 11 times, 12 times. Nobody does anything. And if you really want to get this effective, and, how can we do that? Because, if the attorneys are the criminals and they using their licenses as guides to commit crimes, how are you going to prevent that? That's my question for Mr. Dobson. Thank you.
I'm happy to take that. I think, we're very sorry about what has happened to you. I think any system that you face, the challenge of complicit actors and complicit gatekeepers is, I think, one of the most challenging things you'll ever face. And, I don't think that there are very easy answers to that. And so I wish we had a better answer for you, but that's, that's, I think, the most difficult challenge that most governments face is complicit bad actors who leverage, the framework in a way that is, produces bad results. So.
But this is a system for 11 years. It's not one-time event. It happened to other people too. So it's a system that's been going on for 11 years in the United States.
I guess the only thing that and I know it's very frustrating. I can tell that you're very frustrated, but I would imagine that yeah, of course, and I think that I would just urge you to continue to engage with law enforcement because we're policy folks. We're not in a position where we can deal with specific operational issues.
No, that's my question. How do you reach the ultimate beneficiaries if the attorneys are covering? They actually are the criminals and they're just using fake names and posts while they just, putting that door and you're not able even to know who these people is because they don't exist.
The only thing that I would add from sort of a substantive perspective, in these reporting requirements that we issued on September 30th is the way that we've defined substantial control, the way that we've defined ownership. We explicitly account for the nominee structure where beneficial owners cannot legally hide behind nominee directors, nominee shareholders, things like that. Now, obviously, people can lie, of course, but the point is that we're establishing a framework wherein we will now have the policy tools in place that the investigators, which we are not, can then go out and use those tools to try to correct situations like the ones that you've talked about here.
And that's what I was going to say too. This is one tool, and so there are still other tools as well. So as I talked about, there's still subpoenas, there are still other tools that law enforcement would use. This is a way to expedite this process, but there may still be a need in many cases to use other tools as well.
So I know we started a little bit late, but let's try to take one or two more questions. I see that gentleman over there, I think, has his hand up, and then over there.
Hi, my name is Franz Wild. I'm from the Bureau of Investigative Journalism in the UK. I've got two somewhat related questions. One is, do you see legislation moving beyond the Corporate Transparency Act to the extent where beneficial ownership registers become publicly available? And secondly, to what extent is there a conversation around international coordination of so global standards for that kind of thing, as we saw in European anti-money laundering directives, but obviously, and maybe just if you have time, if you could say something about your thoughts about how to deal with the kind of recent setback in the European courts on. I know you'll probably say, oh, well, this is a European problem, but I'd still, if you'd indulge us, I'd be interested in your thoughts on that.
So let's work backwards. I think Andrew addressed the ECJ decision in part. I think.
Sorry, I did come a bit late. Sorry.
Yeah. So I think we talked a little bit about the ECJ decision. I don't want to rehash, but we're happy to, I think, talk to you afterwards. In terms of the international standards, Ashish, if you want to take that one, and then in terms of sort of what Congress may do next, I think I would just briefly note it took a long time for us to get the CTA, so I think it was a very significant compromise between a lot of different interest groups. I would imagine if there's congressional appetite to make further changes, we will see that from Congress, but I don't anticipate that anytime soon. Ashish, do you want to talk a little bit about the international standards and sort of coordination and cooperation on their enhancement?
Yeah, sure, Young. So that's a very interesting question, and probably we are trying to address that through two instruments. One is through our mutual evaluation process, where, for example, we look at the extent to which countries are cooperating with each other in sharing beneficial ownership information, the extent to which that information is shared in a timely manner, the extent to which that information is helpful for countries in carrying out their own investigations and their own, pursuits. And that's something which we look at more closely when we, for example, look at the country's performance on immediate outcome 2 when on international cooperation. And we also ask countries, not just information, but also case studies to demonstrate how effectively they are working in those areas, and sort of, showcase those case studies where there are some good success stories, so that other countries can also learn from that and see where the success lies in terms of learning from each other. So that's one part of the story where our mutual evaluation processes, especially during some of the recent ones, are focusing more on beneficial ownership, international cooperation. The second part is, as I mentioned, about the policy intent, where we have focused more and more on our international cooperation part of the standards, where we are, for example, expecting countries to share information on basic and beneficial ownership information, without any sort of, undue delay, or without any, prejudice, or without any sort of, taking recourse to any, any impediments which might be out there. So I think the focus is now more and more on international cooperation. Now, this may not work in the context of, maybe the registries talking to each other. That's something which can, which can happen through a technological means. But I think more importantly, what we are looking at is how sort of, international cooperation between competent authorities, both formal and informal, works in real practice, so that it can help countries carry out those investigations in a more effective manner, so that they can we can somehow prevent the sort of dissipation of assets, which we find in many cases where, for example, the moment investigation starts, sometimes you find that we miss the real story, we miss the action, and that's why we are trying to address that through our policy efforts. So both for policy front and assessment front, we are trying to address that going forward. Thank you.
If I can just add one compliment to that, I think in addition to standards and agreeing and raising standards in the way that the review of Recommendation 24 is happening, I think it is also important, given how technically complicated this work is, to also support countries to implement elements. And I think there's a range of things that are happening in relation to that. So just to flag three of them, I mentioned earlier in my speech that the UK is part of a progressive grouping called the Beneficial Ownership Leadership Group. So we're working jointly to support each other to implement a set of beneficial ownership disclosure principles and to encourage others to move in that direction as well. The G7 last year, through the finance track, has committed to supporting 15 African countries to implement beneficial ownership registers. The Extractive Industries Transparency Initiative, for example, has an opening extractives program working with BHP Billiton, which is also supporting countries to take forward progress on beneficial ownership in the extractive sector. So there's a range of capacity building and implementation elements which I think are a really important part of the international progress on beneficial ownership implementation.
Thanks, Andrew. So I want to take two more questions. I know right there and then right here, and then we'll wrap up. And I think some of us can stay afterwards and try to address any other questions that people may have. So, a little right here. Sorry.
Thank you very much. My name is Sheila Masinda from Transparency International in Kenya. Thank you for the panel discussion. I was just really reflecting on another element of this panel, which was the societal benefits of beneficial ownership. And my concern really is that if we're not holding countries to account to ensure that these registers are publicly available, especially to citizens, how do they fully benefit then society in terms of just citizens being able to get access to information so that they can also use this information to hold the authorities and others to account. So I think that's more to Kumar also, because he said that 9%, if I got it right, that almost in their own assessment, that almost 9% of the countries are not fully compliant. So really it's a concern. How do you enforce this so that the issue of transparency and beneficial ownership really benefits us all as citizens? Yeah, I think that's what I wanted to say. And then the other one, and I don't know, maybe the gentleman from the UK, maybe you can answer this because you seem to have progressed a little bit more in this area, is have you managed to also link your registers or data on beneficial ownership to public procurement portals, tax registries, conflict of interest registries? Because I think in Kenya, that's one of the things that we are also looking at, because we've had issues where, when you talk about procurement, where you have, people in government trading with their own, entities, because they are the ones who own these companies. So the next frontier of this discussion is how do you ensure that there's transparency in procurement, but you also need to ensure that there's transparency and also access to information on beneficial ownership and so on. So I think it's important to try and link some of these processes, and I'm just wondering whether there's some countries which have advanced in this regard. Thank you.
Thank you very much. So Ashish, if you could talk very briefly about maybe the stock take, a little bit more about sort of how countries have been implementing the requirements, and then Andrew, I'll turn it over to you to address some of the other elements about the benefit and also what else the UK is doing.
Sure. So in terms of stock take, we did a study of around 120 mutual evaluations across the global network, and the 9% figure was more about effectiveness. So it means that countries do have regulatory framework, legal framework in place. In fact, 52% of them do have those frameworks in place. But the question is whether they produce results. And that's where I think the real problem lies, that, even in spite of having those frameworks, countries are still struggling to get good outcomes. And that's where only 9% of the countries were able to achieve substantial or, high level of rating in terms of evaluation results. And this is where, 9% figure comes. And I agree with the comment that, unless, reforms will not have any meaning unless you see the implementation on the ground. And this is where the real challenge is, to what extent countries are able to translate those tools, those frameworks, those, basic structures into something which produces result. And that, I think, it will be the challenge which we need to face going forward.
Great, thank you. And I thought that was an excellent set of questions. Thank you. I mean, I think you're exactly on the money in terms of saying that is the next frontier in terms of the linking of data across different sort of data sets to draw connections. I would just flag two elements. Firstly, I think procurement and the importance of beneficial ownership information in the procurement sector is really important. I think it links to the wider movement that also is featuring heavily at this conference around open procurement. But also some of the technical, I mean, I know one of the challenges that we faced in the UK actually is around the sort of the question of unique identifiers for individual companies. So it's a really important agenda. It is difficult. We are looking at it in the UK, but much more ground to go. And I agree with you. I think it's the next frontier. Thanks.
Thanks, Andrew. And the last question here, and then we'll wrap up.
My name is Kanat Bek, Chairman FIU of Kyrgyzstan. Translate, please.
So I will be translating his question. Just for information, Kyrgyzstan is a small country in Central Asia. So I have two questions, one small and the second is larger. The first question is for UK representative. Could you please just clarify, I saw in the agenda that you are the head of Joint Anti-Corruption Unit. Is it like a policy department or is it equal to the Financial Intelligence Service? Just for information.
No, it's a policy unit, essentially. There is a separate head of the Financial Intelligence Unit which sits in our National Crime Agency.
Yeah, thank you so much for clarification. So I want to say that Kyrgyzstan has a very good relationship through Egmont Group with all the financial intelligence services all over the world. So in general, our agency works perfectly, and we find all the assets and we can detect and track them. But challenges start usually when we start working on asset recovery. For example, 10 years ago, we faced revolution and the former president, they fled the country and a lot of money went to UK. So his son perfectly lives in UK. He bought a saucer club and he has a residence there. So everything is perfect there with him. So we are facing challenges to return this asset that were stolen from the country. Because all of them who escape the country, when they are coming to new residences, though they pretend to be political people who fled the country because of the political issues. And 5 years ago, the second revolution happened in our country, and a new portion of money went to US. And I want to also use this opportunity to thank FinCEN and Department of Justice and other law enforcement agencies of the US, because we're working very close, and there is a hope that some of the things will be resolved soon. And there is a hope that money will be returned because of the assistance from US side. So maybe it's more not the question, but maybe just a request that, because why I brought these two examples, because that all the challenges start when we start working with the other jurisdiction. And here's maybe there is a suggestion, because we all have, as already said, a different type of legislation, and there are a lot of challenges when we don't have any kind of mutual agreements, and that's why maybe kind of unify or have some global standards on how to bring this money or bring asset back to the country. So, and also maybe you could share, what do you think?
So, I don't want to speak on behalf of everybody, but I certainly note concerns with respect to asset recovery and the challenges associated with repatriating funds. I think, I don't think anybody here can comment on specific cases, but I think we are aware of a lot of the challenges associated with it. And I know that it is a subject of great attention. I know there's work going on in the FATF. I know that the G20 is taking on work in this regard. So it's certainly top of mind for a lot of people, and an issue of significant concern. So it's very helpful to hear the specific circumstances of your cases to make sure that it remains at top of mind for us. So thank you.
And I can just add, I think the challenges that are seen in asset recovery are one of the reasons why I suspect it is a priority for, it was a priority in the FATF ministerial statement, why there is ongoing FATF work, and I think it is a priority as well of the current president of FATF from Singapore. So I think there is attention being paid to it.
So I think with that, I think we very much appreciate everybody's great interest and robust contributions. This is a very complicated issue where there are a lot of views and a lot of complicated issues surrounding it. So very much appreciate everybody's contributions, particularly those of the panelists. I'm very fortunate to have been surrounded by such great experts on a variety of topics related to beneficial ownership and corruption. So if you could give the panel a round of applause and yourselves a round of applause, and thank you so much.